Well, hello everyone. Welcome. I'm Distinguished Professor Larissa Behrendt at UTS and the Jumbunna Institute, and it's my honour to be hosting this event this afternoon, Black Lives Matter, a roadmap for policing and reform in justice, supported by the Redfern Legal Centre, the National Justice Project and the Jumbunna Institute. I'd like to begin by acknowledging that I'm on the land of the Gadigal people of the Eora Nation, and I'd ask each of you to, in your own way, acknowledge the country that you're on, as I pay respects to our elders past, present and emerging. You'd be aware that today's event is in two sessions. We have two different panels, one at 3 and one at 4, with David Shoebridge during the break to give some reflections and thoughts. There's an opportunity to put questions forward to the panel in the Q&A section if you're on the Zoom, or in the comments section if you're on Facebook, and we'll have a few minutes for those at the end of each session. So let's get into our first panel, which is looking at accountable policing in a broad and in a detailed look. And let me introduce our panelists. We have Lindon Coombes, Industry Professor of Indigenous Policy at the Jumbunna Institute, Chris Cunneen, who's the Professor of Indigenous Criminology at the Jumbunna Institute, and Samantha Lee, who is the Police Accountability Solicitor at the Redfern Legal Centre. So Lindon, I'm going to start with you. And I was going to ask you, has the global response to the death of George Floyd surprised you? And what lessons should Australia take from this traumatic death, given that it's put a spotlight on a whole range of issues?
Thanks, Larissa. The initial response didn't surprise me. The issues that people have experienced with police in both the United States and Australia are clearly not recent phenomenon. And there were always things bubbling away, and we have seen riots and responses to previous police incidents. What has surprised me is the duration and focus of this particular movement. Usually it's sort of, there's an event, the 24-hour news cycle takes over, and we forget pretty quickly as a society why people were upset, why this thing happened and why we need reform. So this has been a sustained focus, and that has surprised me. In terms of lessons for Australia, we're constantly hearing that we are not the United States. And yes, there are differences. In some ways, we're worse with our incarceration rate of Indigenous people, but to ignore those lessons it is simply not an option. What the death of George Floyd has shown is that these things happen here. They just don't seem to be as spectacular or as newsworthy for some reason in this country. But I do think that's changing as well. And the reason that it is changing is we're capturing it. These things are being filmed. It was only a few weeks ago, a young Aboriginal boy in Redfern had his feet swept, landed on his face, and that became a significant news item. Now, if that wasn't filmed, that wouldn't have happened. And we know what would have happened with the police officer in the incident. It would have gone away. So for all of those reasons, this has sparked something, and whether it's because people are at home during COVID and they've got more time to sort of sit and watch things and take a bigger interest, I don't know. But this one has stuck, and that's been a surprise.
Thank you. Chris, you've been working in the policing space for many, many years, and across a range of quite significant reports and reviews into the area of policing and overrepresentation. And I wonder what your thoughts are on why we've suddenly reached a tipping point, which I'm sure you've not seen at any other time during the time you've been working in this space. Why have we reached that tipping point? And what do you think we should be putting a spotlight on as a result of that?
Look, I think to the extent that there's been a tipping point, I think it comes from disillusionment, I think, with the lack of change. You know, we've seen 30 years since the Royal Commission, which everyone's aware of. And, you know, there's been discussion, endless amounts of discussion about improving police training, improving use of force, cross-cultural training, diversity in recruitment, you know, courses against implicit bias and so on and so forth. And I guess we're left with the question, well, what does all that mean after 30 years when we're still seeing exactly the same types of problems over and over again? The deaths in custody, whether they're in police custody or prison custody, many of those deaths, certainly most of those deaths, are replicas of the types of deaths that were investigated by the Royal Commission over the decade of the 1980s. And so, yeah, I think there is a disillusionment in terms of what's been promised and what's actually happened. And I think that's really kind of underpins, if you like, this call for change, this demand for change, which is captured in those couple of words of defund the police. And we see the problems of institutional racism still there, exactly what the Royal Commission identified in its reports in the late 1980s, early 1990s, and institutional racism is as much a problem now as it was then. So I think it's the lack of change that's really brought about this this movement at the moment.
Sam, you're the police accountability solicitor, and that feels like a very unique role. I was wondering if you could talk to us about why such a role is necessary and what it entails.
Yeah, thank you, Larissa. And I'd like to acknowledge the Gadigal people of the Eora Nation and pay my respects to elders past, present and future. I'll firstly address why the role is necessary. It is a very unique role, but firstly that police are a part of government. They are a government body and don't sit outside a government body. And for this reason, they are obligated to meet the same requirements as other government departments, and that is transparency, a level of integrity, and a level of accountability. But police are quite unique in terms of their powers. Their powers are extraordinary, and with that power comes an extraordinary responsibility. I would quite like the text within Peter O'Brien's International Torts textbook. He says, with significant power carries with it the corresponding burden of ensuring that such power is not misused or applied arbitrarily or recklessly without proper regard to each person's fundamental human rights. An important thing to acknowledge is that police power is not infinite. It does have limits. Those limits are contained in law, in regulation, and in policies. And it is our responsibility as individuals and organisations to hold police to account to meet those legal requirements. In terms of the actual practice at Redfern Legal, I'm very proud to be working there. It's the oldest community legal centre, I believe, in New South Wales, established in 1977. The police practice was established in 2010. It has a long history of working with Aboriginal and Torres Strait Islander people and policing, and had some amazing people go through the centre. The practice does look at casework, but also is very concerned with transparency of policing practice and obtaining data and trying to identify systemic issues that arise in regards to policing matters. I'd like to acknowledge my co-worker, Sophie Parker, who also does a lot of work with us in that space. The main focus of the practice, as I said, is to share stories, identify systemic issues, and to bring a voice to the people.
Great, thank you. Lindon, I'll come back to you. And obviously Sam talks about the enormous power that's vested in the police. if you look historically, that is a power relationship with Aboriginal people that's quite distinct. I was wondering if you could talk to us about what you see as some of the historic dynamics about the police relationship in the Aboriginal community that we should think about when we think of how the power relationship might work now.
Yeah, I guess the historic relationship has been since day one of conflict and inequity, particularly in terms of power. The police are often seen as the arm that oversights those with property and those without. And of course, our land rights battles have been a big part of that. The role that police have played throughout our history has been significant. They were the ones who enforced theft of land. They were the ones who came and took kids. And we remember that. And we don't have to have a very good memory because a lot of these things are still happening today and police have a role in that. We referred earlier to the treatment of the young Aboriginal man in Redfern. And one of my first responses to that was this happened probably 100 times that day throughout this country, that there was a violent interaction between the police and young Aboriginal people in particular. And when you have those sorts of issues, when you have deaths in police custody within jails, that relationship is utterly broken. And this is what's fueling the current calls that this system is wrong. We can't fix a relationship that exists within these current constructs. And a lot of people have found that very hard to come at. The very idea of defunding the police just blows people's minds because they haven't thought about what it is that police do and the impacts on the lives of disadvantaged people, and particularly Aboriginal people. But it's actually the police themselves that should be the greatest advocates of this, because I have heard throughout my study and throughout my work, police constantly complaining that they are not social workers, that they are not psychologists, that they are not trained in substance abuse and its effects. So all of these things the police are called in to do, and this is part of the relationship and the interactions that we have. And so what we're saying through defunding the police and restructuring this system so that there can be the potential for a better relationship is that these things need to be sorted. They need people who are well trained, who are focused on this, who are able to wield the type of power that Sam was talking about in a responsible and constructive way. So these are the things these are really big ideas, and they're really new to a lot of people. But again, when I was talking about the impacts and the longevity of this particular movement, this particular time, people are starting to think about that, people that wouldn't have thought about that before. And so I think there is this opportunity to do something while this movement is still so strong.
Thanks, Lindon. Chris, I'm going to come back to you a bit later on about the defund the police idea.
Sure.
But I thought what I might ask you next, just in the context of that historic relationship that Lindon spoke to, that obviously continues today to shape those arrangements. I wanted to ask what some of your observations have been about the practice of over-policing in Aboriginal communities over the time you've been working on these issues, and just your observations generally about policing practices.
Sure. Look, I think, when we sort of talked about over-policing back, in the early 1990s, it really became a phrase that was used to describe the interaction with police between Aboriginal communities and police, and it was very much about the nature of policing, the extent of policing in Aboriginal communities. And we often used to point to places like Bourke, where there were a couple of thousand people, majority, well, about half of whom were Aboriginal, and about 36 police stationed there in a small community. I think the nature of policing has definitely changed, really from the late 1990s to the early 2000s. You had the rise of new ideas around zero tolerance policing, the broken windows theory, which influenced policing here in this country as much as it did anywhere else. And that really led to an even greater focus on street offences, on minor offences. And so I think the lesson from that is really the question about over-policing has not improved. If anything, it's got worse. It has a new rhetoric, a new kind of range of concepts and words that are used around it. We've seen the rise of risk, the concept of risk throughout the criminal justice system, and particularly in policing. And we see programs like STOMP, the suspect target management plans being used in New South Wales, again, disproportionately affecting young Aboriginal kids within this framework of risk. But the bottom line of all of this sort of new language, whether we're talking about risk and risk assessment or broken windows theory or zero tolerance, underpinning that is still very much an older story about over-policing, about an extensive nature of contact between police and Aboriginal people, poor people, disadvantaged people, people with mental health issues, cognitive impairments. And so, I think the problems are still there, although they've been redefined with different types of language, if you like, but still the same targets.
Thank you. Sam, I was wondering if you could share with us through your work, looking at the types of complaints you're working on, what are some of the key issues that keep arising, and particularly if you could provide some examples to give people a bit of an understanding of the sorts of issues that come up in your work.
Yeah, thank you. Look, there's some key issues that routinely come up, but I'll concentrate also on issues that come up for Aboriginal and Torres Strait Islander people. There's certainly an issue that arises a lot, which I would probably term as generational harassment of police. For example, we have a client who lives in a regional area in New South Wales, an older woman with various children. Police tap on her door and ask where a relative is. She doesn't know. They then barge into her house without a warrant. They then go and harass her son or daughter in another space. And that's quite a common theme that comes up in our practice. In terms of, what you do with that, it doesn't always necessarily fall neatly within a legal or civil matter. Sometimes a lot of policing falls outside any kind of legal avenue, and that's why this complaints practice is very necessary. Other issues that come up is a failure to act. For example, a person may report an alleged crime and police have such wide discretion as to whether they will act upon an allegation, and that will depend on who's making the reporting. There's no doubt that we see through our practice that police make a pretty quick assessment. If a person is Aboriginal, they're known to police that they will not act on various allegations, and sometimes these are quite serious allegations of violence against them. Another common issue that comes up, particularly for Aboriginal youth, is routine random stop and searches. Chris touched upon this in terms of the STMP. A young man, for example, or young boy is going about their daily routine, or sometimes even scared to go out of their house because of police stopping and searching them. And sometimes we have clients who have been stopped and searched 30 or 40 times in a 2 or 3 year period.
Thank you. I think one thing that comes out of what you're saying through your work, and I think it's highlighted through Chris's work as well, is the amount of discretion that police have in terms of making decisions within the frameworks of the laws that they're implementing and within those regulations. Lindon, police are products of the broader community, and I was just wondering what your thoughts were about whether police training is part of the solution, or how we change attitudes more broadly, thinking about the work you've done in the reconciliation space.
Yeah, I think it's all of those things. We were talking before about a redefinition of the role and indeed structure of police and policing. My problem with that, and I think Chris alluded to it with the training, is that these things have happened. We've had inquiries, royal commissions. We've seen corruption episodes within police and the abuse of the enormous power that they have, which is why people have made very admirable attempts to try and work within the current structures and the current systems to get reform, to make things work better. But maybe I'm just old and grumpy, but it seems like it's becoming futile. And I think that's why we're getting to this point about sort of breaking it down and putting it back together. One of the things that just this week we had Commissioner Fuller on Sky News talking, just making stuff up around Black Lives Matter protests, making stuff up around the potential economic impact. The ideology and politicisation of his position was incredibly clear. And that's really concerning, that police have these sorts of approaches to people. And when we think about their training and the traditions of police, these are the sorts of things that, again, very big issues that we need to address, that people in power have enormous responsibility. How do they use these powers to do better? So one of the calls throughout the Black Lives Matter protests is that people were imploring police to say, you're one of us, you are part of this society. And to see how quick police are to violence against protesters. And it was almost, when we had the protests here in Sydney, and there was an incident right at the end of the day at Central after it had been very well organised protest, people were obeying COVID restrictions, people with masks, everyone was very respectful. And it was like the scorpion and the frog to me. It was like the police couldn't let that day go without an incident. And it appeared that they were determined to do it, to create a response, and the media was almost begging them to. So this is the sort of dynamic and the social construct that we're operating in. And maybe, I'm just out of ideas about how we fix it in this current system. Otherwise, we need a new system.
Thanks, Lindon. Sam, I want to come back to you, and obviously one area of work that you've really concentrated on is the use of powers around strip searching. And I was wondering if you could tell us a bit about the campaign and why it's important, what issues it's raised.
Yes, thank you. We developed a campaign to change and shed light on strip search practice in New South Wales after a number of people came to our practice and described what we thought and believed to be unlawful strip search practice. And from our casework, we identified a systemic issue, we believe, which is unlawful strip searching and a very widespread practice. And I believe a practice that has festered for many years, and that Aboriginal and Torres Strait Islander people have borne the brunt of this practice over a long period of time. So we commissioned a report from the University of New South Wales Law School. Dr. Vicky Sentis and Dr. Michael Krukok undertook this report. And I just want to share with you some of the statistics that we have. What's the key findings being is that there's been a 20-fold increase in strip searches since 2006, moving from 277 strip searches to over 5,500 strip searches in 2018. I believe, though, that there's a dramatic underreporting in strip searches, so you could probably even at least double that figure, and that also came out of the public hearings done by the LEC in regards to strip searches. On average, 63% of strip searches find absolutely nothing, and when they do find something, around 82% of those are for minor drug possession. In terms of Aboriginal and Torres Strait Islander people, they make up 10% of strip searches in New South Wales, even though they only make up 3% of the actual population. They also made up 22% of all recorded, I emphasise the word recorded, strip searches in custody. As I said, there'll be many strip searches that have gone unrecorded over a very long period of time. The youngest recorded Aboriginal child strip search was of 10 years of age. The oldest is 75 years of age. The majority of strip searches happen or occur to 20 to 30-year-olds group. 82 Aboriginal and Torres Strait Islander children aged between 10 and 17, those are the recorded ones, have been strip searched in a 2-year period. We did find some hotspots in terms of strip searches, regional areas, Nowra and Taree, also in the Sydney government area. But what it does say to me is strip searches have become routine by police. Police aren't following legal thresholds that they are required to. Major concern is that the law fails to reflect any form of child protection principle. When you think about it, you have an adult ordering a child as young as 10 to take off all of their clothing in a strange environment. What other area of practice would allow that to happen? I think it's absolutely appalling that it should still exist in this day and age. It's an enormously invasive and humiliating process. There's awful stories out there. Some, as I said, that have never been recorded. And it's time that this practice does stop. And so we have announced a registration into a class action. I'll send out the link for that registration. We would like Aboriginal and Torres Strait Islander people to come forward who have been strip searched in the past 6 years. Being strip searched doesn't mean taking off all of your clothing. It could be a police officer looking down the top into a young woman's breast area, pulling out the back of their pants and looking down into their underpants or private areas. It could be taking off all of your clothing. But if you have been strip searched in the past 6 years, then please go to our website or Slater and Gordon's website and register for the class action. You're still on mute.
Thank you. That was bound to happen at some stage. Chris, I asked you earlier about your observations about over-policing over the many years you've been looking at it. And I was wondering, perhaps on a more positive note, changes you've seen perhaps since the Royal Commission that you think have made a difference?
Well, it's a surprisingly difficult question. I think, to be positive about it. I mean, we know that there's more Aboriginal people in prison. We know that police violence is a sort of ongoing problem, and we know that the time when the Royal Commission reported was a relatively optimistic time about bringing about change in the justice system. And I think what we've seen, is often progressively more punitive approaches to law and order. So having said all that, what can we say that's positive? Well, I think there are positive things that can be pointed to, and that's particularly in relation to the role of Aboriginal communities in themselves taking on these issues and whether it's engaging within the current system through things like the Murray Court or the Koori Court, Noongar courts and so forth. I mean, they're all, you know, post-Royal Commission phenomena. I mean, and they're positive, I think. We've seen other areas where there's been the growth in Aboriginal community-run programs for young people, for adults that are in contact with the justice system. We've seen the development over the last decade of justice reinvestment, and you know, the most well-known example of that is in Burke, which has had quite significant positive impacts on contact with the justice system. But there are lots of other less known or less well-known programs under justice reinvestment that are running around the place by Aboriginal community organisations. Port Adelaide's an example. Halls Creek, where there's some great work going on there under the ideas of justice reinvestment for young people, not only in Halls Creek, but in surrounding communities like Warman and Balgo and so on. So I think there are positive things that are happening at a community level that are Aboriginal driven and controlled. And I think, yeah, despite the kind of vast array of negative stuff surrounding all of this, you know, at a community level, we see some really great things happening.
I was going to come back to you, but I think I'll go into my last question for you now, because it seems to flow on from what you're saying, and I'm just mindful of the time and wanting to get one or two audience questions in. But I was wondering what your thoughts around the defund the police approach could be going forward, especially in its impact on how we may look at law and order in the future. Yeah,
look, I think that the greatest thing about the defund the police is that it captures the need to think differently. And I think Lindon was sort of alluding to this earlier as well, that, yeah, we need to reimagine what's happening around in relation to policing. And I don't think it's going to be an easy task. I don't think the police, no matter how rationally we might discuss it with them, are going to voluntarily give up power. And we can see the problem straight away with the current attempt to raise the minimum age of criminal responsibility, which, you know, police have not been supportive of in general, because they don't want to lose the power to arrest 10-year-olds, you know. And if we can't get over that barrier, how are we going to get over the bigger ones around defund the police? But look, it does open up an opportunity to think about how we shift resources to communities, to community-based organisations, to services for people, rather than seeing every problem in society as a policing problem. And we do that. We've just done it with COVID-19. I mean, who was the lead agency in New South Wales? It was the police. I mean, that speaks a volume about how we deal with public health issues. We need this new discourse, and I think the defund the police slogan, it is a slogan, you know, captures a different way of thinking about how we do things. Thanks, Chris. Sam, I just wanted to check in with you finally, just to see what changes you think we should be prioritising going forward and what you're working on next.
Two main things. One thing, as I have just spoken about, is change to strip search laws and practice and bring damages for people that have already been traumatised. But another area that we're about to look at is the actual complaint system itself. It's flawed. It needs fixing. I like the words of Dr. Vicky Sentis, who wrote an excellent paper, very short paper, and she says a core component of accountable policing is an effective complaint system, and is well established that justice and accountability are undermined in a system where police investigate themselves. The current complaint system is deficient. It holds huge barriers for Aboriginal and Torres Strait Islander people who want to complain about police behaviour but don't want to complain to police about police behaviour. Not all wrongdoing by police is unlawful. It could just be purely improper. And therefore, as I said, it doesn't fall into any kind of legal action. And so there has to be an avenue for a complaint system, a proper, equitable complaint system to exist. It's also really important that that complaint system is well resourced, has expertise, and has all the necessary funding on an ongoing basis to support a whole range of complaints. The most important complaint system will deal with just the daily policing that young people and adults come against. Sometimes not all complaints fall into serious misconduct, but it's the daily routine policing that requires an avenue for accountability.
Thank you. Lindon, I think your observation about feeling like reforms within the current system are futile is a bit of a chord. So my final question to you was how agendas like truth-telling and treaty might lead to more substantial changes. Is that where you think there might be some hope?
Yeah, I do. You need to change the rules of the game, not just in policing, but more broadly. Working in Aboriginal affairs for over 20 years, I am absolutely exhausted showing up to government without power, without leverage, without justice or equity. We have to be 10 times smarter to get what we need. And to do the things that we want to do. And for me, the framework of a treaty resets the relationship and these things that we're talking about. So a reallocation of power, and as Chris sort of inferred, the police aren't giving this up lightly at all. There's not even a change in the language to say, yep, look, something's wrong here. You just heard from both Sam and Chris, kids getting strip searched, the violence, police investigating themselves, the age of criminal responsibility at 10 being argued against. They're not going to yield up. And so we need a completely different system in which we can respond to that, because at the moment the deck's stacked and it's very difficult for us to get justice. It's very difficult for the families of those who have died in custody to get justice, and that needs to change.
Thank you. I might just try and pull in a couple of the questions from the audience, from everyone online. I just wanted to share Alexis Goodstone's comment. She said, we need better minister and commissioners to lead the police with progressive evidence-based policy. How can we get the community not to settle for less? Which I'm going to leave with all of us as something to ponder, because I thought a good question perhaps for Chris and Sam might be a comment that's come from after hearing Lindon's frustrations about reforms within the system appearing futile. The question is, what can law students and emerging lawyers do to assist the Black Lives Matter movement in Australia? So maybe you first, Chris, and then you, Sam.
Sure. Well, I'm going to say something which is an historical answer to a contemporary question. And the way in which the Aboriginal legal services started in Australia, in Redfern, was by law students going and working with Aboriginal activists to directly assist Aboriginal people. And that's really the answer to the question. And the outcome of that is a Aboriginal organisation which has been running for 50 years and is now a group of national bodies that represent Aboriginal people. And law students, activist law students, were a great help in setting that up.
And Sam?
Yeah, thanks, Chris. Yes, we still utilise many law students at Redfern Legal Centre. They are passionate and a fantastic resource for any community legal centre. So I do encourage them to reach out to community legal centres, but to other Aboriginal and Torres Strait Islander organisations. But I think mainly is to be informed about police powers and their limitations, and to inform others about those limitations as far and wide as possible.
Thank you. And I will actually throw the question to you, Lindon, perhaps with a slightly different flavour, and ask from your perspective, what can our allies do to help the Black Lives Matter movement?
To listen, to provide the space, to not centre yourself in these discussions. And I say that just because oftentimes I've worked in not-for-profits and different areas, and people want to help Aboriginal people, naturally with their own skills and abilities, but often that's not what is required. Sometimes the best intentions lead to not great outcomes. And so really listening to Indigenous people, one of them always gives me some solace, because I know I've sounded a bit cranky and frustrated here, and I am, but I do believe in the strength and wisdom of our communities, of Indigenous communities. And if we're able to listen, and it is a skill, is something to develop for all of us, to hear what those communities are saying, and then try to respond to that in a respectful way. That would be my general advice.
Great, thanks. I think we can just squeeze one more quick comment in from you, Chris. There's been a few questions raised about, I guess, thinking about the proposals or thoughts that have been given to what justice might look like outside of policing and prisons. And I wonder if maybe you could just quickly refer to some of the big ideas in that space that go beyond thinking about those institutions in terms of what justice might look like.
Look, I think to go back to Lyndon's point, if we're thinking about this in relation to Aboriginal people in Australia, it has to be about decolonising the institutions within which we work. It has to be thinking about what justice means for Aboriginal people. And there's absolutely no reason to believe that Aboriginal people in Australia are going to define justice in anywhere near the same way as non-Indigenous colonising institutions define justice. So I think, the big idea is to actually think about what the decolonisation of justice might look like, and the way in which Aboriginal people and Aboriginal organisations understand justice, and the whole kind of broad parameters about what justice might mean from reparations, through to kind of more mundane interactions with maintaining social order within communities and so on.
You're on mute again, Larissa.
Sorry, thank you. Well, I was just saying, if this was a live event, you'd be getting thunderous applause, and if this was a live event, I wouldn't keep putting myself on mute. So I just wanted to once again thank Lindon Coombes, the Professor of Indigenous Policy at Jumbunna Institute, Chris Cunneen, the Professor of Criminology at Jumbunna, and Samantha Lee, the Police Accountability Solicitor for Redfern Legal Centre. Lots of good questions still in the Q&A, but hopefully we'll get a chance with our next panellists for people to ask some more questions. And just a quick shout out, there's an Amnesty panel for people who are also interested in continuing to think about these issues. It's on the 5th of August at 6:30. It's called Australia's Shame, How the Justice System is Failing First Nations People, and you can see that on Eventbrite. So it's now my great pleasure to turn over to the next part of our event this afternoon, and that is for me to introduce David Shoebridge MLC, who was elected to the New South Wales Legislative Council in 2010. He is the Greens spokesperson on a range of things, a lot of them very pertinent to our issues today, including justice, Aboriginal issues, and child protection. David's been an absolutely tireless advocate for changes for reform and is a genuine campaigner for the rights of Aboriginal people. Anyone who has worked in the space knows what a great ally and advocate David has been. So it's a great honour to be working with him myself on a number of issues. I admire his energy, commitment and integrity. And I will hand over to you, David.
Oh, thanks, Larissa. And thanks for that, I think, overly generous introduction. And it's excellent to be here following such a powerful initial panel. I'd like to start by acknowledging that where I'm speaking from, the New South Wales Parliament, is on Gadigal land, and pay my respects for those elders past, present and emerging. And I'd also like to start by acknowledging that as a member of the New South Wales Parliament, I'm actually a member of an institution that has created many of the problems you heard spoken about from those initial panellists. Whether it's the laws that allow for the over-policing, it's the resourcing of police that allow for the over-policing, or the refusal to confront. the systemic injustices that First Nations people face, as well as, of course, laws that continue to dispossess and harm Aboriginal people in this state, and in most cases prize resources and exploitation ahead of things such as Aboriginal traditional cultural sites and Aboriginal ownership of the land. So speaking from the New South Wales Parliament, I think you need to acknowledge that I'm part of an institution that is a big part of the problem. And indeed, I think one of the things I wanted to start this discussion with, and I'm happy to take questions from the Q&A, so please put questions on the Q&A. I'll try and answer as many as I can in the short space that's available. I wanted to take a little step back from the discussion about police and policing, because you've heard all of the problems with policing, and you've had three panelists who set out a number of kind of critical reforms. And the question is, well, why haven't they been adopted by the New South Wales Parliament? Why haven't we put in laws that limit the way in which police do strip searches? Why haven't we put in laws that put in place essential protection measures so that Aboriginal kids are being constantly stopped and searched under things like the Suspect Target Management program? And I think one of the reasons is that the New South Wales Police have an extraordinarily hold on politics in New South Wales. Perhaps one of the most powerful political voices in New South Wales, I think, isn't the Liberal Party or the National Party or the Labor Party. Perhaps one of the most powerful political voice in New South Wales, in my mind, is the New South Wales Police, and often that comes through the New South Wales Police Association. So there's a lot of barriers to reform structurally within politics. But I think one of the other key issues, I believe, that comes to the fore when you talk about policing and the over-policing of Aboriginal people in this state is that it's just one small part of the way in which the state of New South Wales, and it's mirrored across the country, over-polices and acts in a racially biased way against First Nations peoples. It starts at the very beginning of an Aboriginal person's life journey in somewhere like New South Wales. I mean, just today, my office was contacted by a young Aboriginal mum who had her baby taken from the hospital at birth because she was on a thing called a high-risk birth alert. And high-risk birth alerts are where far too often Aboriginal mums are conceived to be a risk to their child before the child is born. They're not told they're on a high-risk birth alert. They go into a hospital, the high-risk birth alert is activated, mum goes out the front door, baby goes out the back door, child is taken, stolen generations continue. And the child protection system itself in New South Wales is horribly skewed against First Nations peoples. And we know that Aboriginal kids in this state are 10 times more likely to be taken from their families than non-Aboriginal kids. And that begins a journey for many Aboriginal families and Aboriginal kids of dysfunction, engagement with the juvenile justice system, and a massive overrepresentation of Aboriginal kids in the juvenile detention system in New South Wales. Tonight, half the kids in juvenile detention in this state will be Aboriginal kids, well over 10 times greater than what should be the representation. And then that engagement in juvenile detention flows through into engagement in adult incarceration. A third of the women in jail tonight in New South Wales will be Aboriginal women. A quarter of the men will be Aboriginal men, grossly overrepresented. And that flows into health impacts, socioeconomic impacts. So at each point where the state interacts with Aboriginal people in New South Wales, and it's mirrored across the country, at each point there is, in my observation, a powerful racial bias against Aboriginal people. And policing is one part of this. So when you're talking about reforming policing to improve the outcomes for Aboriginal people, you need to keep in mind that we actually need to reform the whole state interaction. And trying to persuade my fellow MPs in this institution that we actually have a systemically biased system against First Nations people. We have institutional entrenched racial bias at pretty much every point that the state interacts with First Nations people is, I think, a pretty fundamental challenge, because it challenges their worldview. It challenges their view about Australia being a fair, just and equitable society. And I think that challenge is one of the reasons why it's so hard to get some of the critical reforms, because it challenges our sense of ourselves. And so that I suppose is my rant at the beginning. I would say the answer to this, in my mind, the answer to all of these, what often seem to be intractable problems, is actually self-determination and empowerment and resourcing of Aboriginal communities. The answer for Aboriginal kids being taken is to actually empower Aboriginal families and Aboriginal kids and resource them so that they make decisions. The answer to dealing with issues in relation to juvenile justice is resourcing and acknowledging and empowering the elders and those knowledge circles in Aboriginal communities, and giving economic empowerment to those Aboriginal communities and families so that there's this positive, a positive response. And in part, and in a substantial part, the answer must be in a concept of justice reinvestment. We call it defunding the police, but the way we traditionally talked about it in New South Wales is justice reinvestment, taking the resources that are currently being used to jail and criminalise Aboriginal communities and investing them into strengthening and having not only the right to self-determination, but the resources and the support to make that self-determination work. So I can see there's a couple of questions coming in. One of the questions is there a place for police in Aboriginal communities at all? Well, I think if there is, it's a very limited place. And you heard Lindon speak about just the reaction and the assessment that Aboriginal people have of the police, of our courts. For pretty much every Aboriginal community member that I've worked with, every group that I've worked with, their perception of the police, their perception of the court system is fundamentally different to non-Aboriginal people. They see, in pretty bald terms, they see an ongoing invasion colonialist state criminalising their kids, taking their land. And when they engage with organisations like the New South Wales Police, they know they're engaging in large part with an occupying power. And I think that's a very valid perception because that's the reality. So I believe that the less interaction we have between the police and Aboriginal communities, in large part, the safer Aboriginal communities and the stronger Aboriginal communities will be. Of course, you know, there'll be a necessary element of policing for serious crimes and a necessary engagement of policing in Aboriginal communities within our current system, but it should be a far, far smaller footprint. And I think that we should acknowledge that every time there's an interaction between police and Aboriginal communities, there's a very strong racist bias in that interaction. I've been asked how do mothers get placed on the high-risk birth alert list. Jacqueline says it sounds like a process that would happen in a movie, and it's appalling that this is happening as we speak. Well, Jacqueline, yes, I agree with you. It's absolutely appalling. The most usual way in which a woman finds herself on the having been identified as a high-risk birth alert and been on the list is if they've had a previous child and they've had an interaction with family and community services with a previous child, or if they themselves were taken and were in the out-of-home care, mostly under the care of the minister, and therefore they may find just as they progress into adulthood, they're automatically subscribed on the high-risk birth alert. And women are not told about this. Often the first time they find out that they're on a high-risk birth alert is when they come into hospital. Their name is run through the system, and then there's pretty much an automatic removal of their child. And you talk to some women, and maybe their second or their third child. They may, in some cases, have had terrible difficulties with their life and their partners with their first child. They've got their life back together. They're on a strong footing, but they're still on the list, and they still face having their child removed as soon as they come, as soon as it's born from hospital. The amount of grief that causes, the amount of pain that causes in having a baby taken at birth is pretty hard to comprehend. And indeed, the most recently released report on the out-of-home care system and how it interacts with Aboriginal people, the Families Culture Report, makes it clear that high-risk birth alert systems should be completely abolished and removed. And that's something I fundamentally agree with. And indeed, there's a blueprint for reform that the New South Wales government could take when it comes to reforming the out-of-home care system to deal with some of those dreadful statistics, and that is the Family is Culture report. There's over 120 recommendations in there. The government has recently responded to it and has largely parked the majority of those key recommendations. There's a lot of work to be done. The last thing I'd say, I've got a question here, sorry, from Romina about how about Aboriginal and Torres Strait Islander people trained as police? Would that have a positive interaction in communities? Well, I think it have a marginally beneficial impact. Having more Aboriginal and Torres Strait Islander police, New South Wales Aboriginal police, would have some assistance in dealing with the culture of the New South Wales police. But that's not going to change the nature of the animal, which is the New South Wales police. It's much more likely to put those Aboriginal police in a highly compromised position when it comes to dealing with their community. And that's been the history in large part of Aboriginal police members to date that you speak with. Yes, there's a marginal benefit, but more often than not, the price is paid by the individual Aboriginal police officer who finds themselves being compromised and often at odds with their community, rather than there being a fundamental change in the New South Wales police force. I don't think that's the way we get cultural reform, but it's not a bad thing in and of itself. I've got from Madden, is it really socially and politically impossible for current New South Wales legislators to put forward legislation that completely closes and dismantles all juvenile detention centres and juvenile prisons? Well, I'd say, unfortunately, I think it is yes at the moment, but surely that should be our goal, to close all juvenile prisons, to stop jailing kids. The current challenge at the moment is raising the age of criminal responsibility to 14. And I fear that may even be beyond the current crop. But it's not as though there is no hope. I think you must engage with mainstream politics. You need to engage with the New South Wales Parliament. And the good news is that there are small cracks appearing. We, for example, established just a month ago a motion that I put on the books on behalf of the Greens, but was unanimous, well, almost unanimously adopted. I think one nation voted against it. You know, enormously broadly supported in the New South Wales Parliament, which was to establish a multi-party inquiry into how we fix the oversight of deaths in custody. And in establishing that inquiry, the Parliament acknowledged the gross and unacceptable overrepresentation of First Nations peoples in deaths in custody. And it's in the context of that the inquiry has been established. If you want to know more about that inquiry, I'd urge you to make a submission, whether you're an individual or an organisation. Submissions are due by the 24th of August. And we really need to make sure for those Aboriginal families who have lost somebody to a death in custody, that when there's an investigation of them, that it's done by an independent, genuinely independent body. It's not done by the prison system itself. It's not just done by the prisons and police, but we have a genuinely independent body so that people feel like, families feel like they have justice and a sense of integrity in the investigation of deaths. Because as we know, First Nations people have grossly overrepresented in deaths in custody, not just in New South Wales, but across the entire country. Look, I think I'm about out of time, but I have one more question. I did promise to try and run through them quickly. Jade has asked, what are the strategies moving forward for police to respond to Aboriginal and Torres Strait Islander individuals and community to create more diversionary responses to the justice system? Well, the first thing I'd say is the less interactions between the police and Aboriginal and Torres Strait Islander communities, the safer, in large part, Aboriginal and Torres Strait Islander communities will be. And so we need to have as many strategies as possible to avoid police being the first responders. Where there are instances of mental health, we should be sending mental health teams into communities. Where there are concerns about breakdowns in family setting, we should be sending in highly trained social workers, or we should be engaging with the aunties and the uncles and the grandmothers in those Aboriginal communities and using them as our initial response, rather than sending people in with a uniform and a gun and a taser, capsicum spray and a baton and a mentality that is the New South Wales Police Force. And I think that is the answer in large part to making Aboriginal communities safer in this state, reducing as far as possible their interactions with New South Wales Police, because the extent of the over-policing, the overcharging is I think, a significant part of the problem. Now, Larissa, as I understand it, I have now run out of time.
Yes, sadly, but thank you for that. It was great. And I didn't overpromise. You didn't underdeliver. David, thank you so much for joining us and giving your insights. It was great for people to get a sense of just how much work you're doing there in the Parliament, and to know that actually you are a good point of contact for people who are interested in those areas of change. So thank you very much for being with us this afternoon and all the work you're doing. Well, it's now my privilege to move to our second part this afternoon on the criminal justice system in this seminar, Black Lives Matter, a roadmap for policing and reform in justice, supported by the Redfern Legal Centre, the National Justice Project and the Jumbunna Institute. Our second panel this afternoon consists of Carly Warner, the CEO of the Aboriginal Legal Service New South Wales and ACT, Thalia Anthony, who's from the law faculty at UTS in Sydney, and George Newhouse, who's the National Justice Project head, the CEO, I guess, equivalent, and also oversees CopWatch. So thank you, the three of you, for being with us. Carly, I thought I'd start with you, and I guess a big picture question really, but as a result of the increased attention to the issues facing First Nations people and the criminal justice system as a result of the Black Lives Matter movement, what do you, from your perspective, think are the most important things for Australia to know about that relationship between First Nations people and the criminal justice system?
Thanks, Larissa. I want to acknowledge country. I'm on Gadigal land and pay my respects to elders past and present. Sovereignty never ceded, and always was and always will be Aboriginal land. For me, the starting point, whatever our race, our background, or our postcode, we all want to move through our communities without fearing for our lives or our loved ones. I think the Black Lives Matter movement has brought renewed focus to racial injustice issues in the past few months. And we don't need to look to America to see the consequences of systemic discrimination. We absolutely see it here. And what I want to emphasise today, and perhaps to be a takeaway, is that, and following really from the comments from Chris Cunneen and Lindon Coombes in the previous session, that this is how the system has been designed, and pose a reflective question of actually what kind of society do we want to belong to? Following invasion and the continued dispossession, new laws were imposed. They were used to rule over our communities. We had no say in those laws that were created, and the police and the courts have historically played a fundamental role in the oppression of our communities. And it's important to remember this history and legacy when we think about the relationship between our communities and the legal system today. It's so incredibly heartening to see that people of good conscience right around this country and the world are demanding that we respect and honour Black lives. But I really want people to do some of their own research and consider whether tinkering around the edges of this system has had a meaningful impact and whether it will have a meaningful impact. That tinkering has led to massive capital investment in expanding prisons and jails and more privatised prisons. Sentencing laws have been through radical changes, including implementation of mandatory sentences, mandatory minimums, recidivist offender laws like 3 strikes. And in addition, the criminal law has been expanded, dramatically increasing the number of behaviours for which there is criminal liability, in turn widening the net of the justice system and the role of police, as we've just heard in the last discussion. And so I guess for me, the result of tinkering is seeing our kids, our mums, our dads subjected to the disparate treatment at every stage of the justice system. And there's just story after story, from unlawful strip searches of a 16-year-old Aboriginal boy in the street of a New South Wales regional town, the horrific treatment of a young person by a police officer in Surrey Hills, And we had a young person who was forced to move towns after police harassment got so bad. He was placed on the state's suspect target management plan. And for no other reason that his dad had been previously incarcerated, he was targeted. So this is the tinkering that we're seeing. And this, these stories aren't one-offs. This is just the tip of the iceberg. And of course, at the other end of the scale, we've got so many families grieving. And I really just want to acknowledge the work that all of these families have been doing for so long, and the load that they have carried in campaigning for change or while they're grieving.
Thank you. I want to pull up just, the idea that there are other ways forward, the not tinkering around the edges idea that you had, and ask Thalia. And this question's come up a bit in the questions from the audience as well. But of course, the best way to prevent overrepresentation in prisons is not to send people there in the first place. From your perspective, Thalia, what are the sorts of alternatives we should be looking at? You're on mute.
Thanks, Larissa. Also like to acknowledge Wongal people of the Eora Nation, always was, always will be Wongal land. I think the foregrounding principle when we look at alternatives is that any alternatives need to be designed, owned and run by First Nations communities and organisations. Carly's absolutely right in talking about tinkering, and this is no different when we look at alternatives. So the state's quite good at introducing alternatives. For instance, after the Royal Commission into youth detention in the Northern Territory, one of the recommendations was to have bail accommodation as an alternative to youth detention. So what did the Northern Territory government do? They set up a facility across the road from Dondale and called it bail accommodation, but it was just prison in another name. And it's the same with New South Wales, for instance. They've set out all these community and intensive corrections orders that have harsh conditions and set people up to fail. And so ultimately bring more people into prison, widen the net. And so the alternatives need to be things that are going on, such as successful programs run by Aboriginal women, like Mudjingal in inner city Sydney, like Waminda on the south coast of New South Wales, where Aboriginal women are providing a holistic approach to an alternative to prison. So they're looking at things like strengths-based programs, healing supports, setting up safe housing, getting the women jobs, and very importantly, support for family restoration and strengths. So it's providing that overall approach to social, cultural and emotional well-being that is needed. And I think that's the way to keep mob out of prison. It's to actually look at things outside of the criminal justice system rather than just the justice system trying to undertake the impossible task of fixing itself.
Thanks, Thalia. George, I want to bring you in now and I guess dig down into one of the issues that seems to be intractable, in that, despite the Royal Commission, we still really average about one death in custody a month. And you have done a lot of work on coronial inquests into deaths in custody. And I was wondering if you could pull out for us from that work that you're doing, what some of the recurring themes are. What are the things that are still in the system failing that means that we're still seeing those statistics that obviously have a huge human impact?
Well, thank you, Larissa. A death in custody is the ultimate systemic failure. Individuals only end up in custody because of failures in other systems like social services, education, child safety, policing, the criminal justice system. And quite frankly, the coronial inquest is the final indignity for many Aboriginal and Torres Strait Islander families. They come into the system seeking truth, accountability, and some comfort. And often they're let down by that system that doesn't represent or respect culture, and in many cases can re-traumatize families where colonial definitions of justice don't match family or community expectations. And the Royal Commission into Aboriginal Deaths in Custody prioritised inquests as a mechanism to ensure that Aboriginal and Torres Strait Islander deaths are properly investigated and recommendations are made to ensure that deaths aren't repeated. But unfortunately, many coroners, and I've said this before, Larissa, with you, not all of them, but many, continue to let Aboriginal people and Torres Strait Islander people down on a consistent basis. And just in that regard, I think a major reform that we need to see is the appointment of Indigenous coroners to oversight Indigenous deaths. And then you might see a better outcome from that process. But there's, just to come back to answer your question, a death in custody is usually the combination of failures in all of government services, from social, education, the Department of Child Safety, policing, the criminal justice system. And at the moment, I don't think that the coronial system is actually assisting either.
Thanks, George. Carly, I thought I'd come back to you. There's obviously been a lot of discussion about the role the federal government can play in these issues. Law and justice issues are ostensibly state issues, but there has been talk about national justice targets and a lot of advocacy for them. And I was wondering if you could talk a bit about why they're necessary and how they'd help, what they should look like, and any reflections you've had on the government's recent announcements about them.
Almost 30 years ago, the Royal Commission set out the roadmap for change, and yet Aboriginal and Torres Strait Islander people continue to die in custody and be locked up at alarming rates, and this is not new for us. I think it's something that we as peoples are very used to, is this federalism argument and this handballing of whose responsibility everything is. It's my view that if national justice targets were in place, then we'd be able to demand the annual reporting and the accountability. The Commonwealth would not be able to escape responsibility for a lack of progress and a lack of leadership. I think justice targets are critical. I think they provide an important vehicle to drive accountability and resourcing to meet those goals, but they must be meaningful. And as I said before, if we're going to have justice targets that are based on the current ways that a justice system operates, then we're not reimagining how we're going to actually reduce that over-incarceration. It absolutely involves people turning everything on its head. And I think that idea has been perhaps a bit confronting for some, but I also think that's power, and I think, as previous speakers have mentioned, and people don't want to give up that power. The overwhelming response from community to the draft targets that have been reported in the media over the past few weeks is that they want to see stronger, more ambitious targets that would end over incarceration urgently, rather than a completely unacceptable proposal of 2093. Throughout the Closing the Gap refresh process, our position has been that governments can end the over-incarceration of our people. NATSLS has been asking for parity within 10 years, or an 80%, which would get parity in 15 years for adults and 19 years for kids. I think for me, you know, who of us are going to be around in 2093 to hold people to account? The solutions from countless inquiries and royal commissions are really clear. And now we need to see strong political commitments with sufficient resources to flip business as usual on its head. And I hope that when National Cabinet meets, we will see that ambitious justice targets are adopted, because anything less is unacceptable.
Thank you. Thalia, I want to turn to you now. You do a lot of work in the space, advocacy research, but you do also teach within a law school. And obviously that's where we're training the profession, whether they become judges or lawyers, and they're all part of this system. I was wondering, from your perspective, what would you like to see in terms of what legal education and judicial education focuses on? And could that be a way to make a difference?
Yeah, a great question. I think it could be. I would say the first position is to diversify the cohort that's admitted to law schools, to the legal profession, and to the judiciary. There's a tendency for law schools to be breeding grounds for white graduates from private schools that have rarely seen, disadvantage or marginalisation. So there needs to be much better access for First Nations students and people. And that flows on then to the profession and the judiciary. And then within our law schools and continuing legal education, there needs to be mandatory education on systemic racism, including deaths in custody, police violence, colonisation, but not to be taught as a historical artefact, but as a living experience that occurs within the parameters of our legal system. And we need to teach that the judiciary is not only a check on political authority, but it's embedded in hierarchies that are invested in racism. So once we are able to accept these truths within the law schools, we can start to change thinking among our students and the legal profession. I also think, and this it dovetails with something Chris was saying earlier, that law students and law academics need to be activists. And Jumbunna's been, trailblazers in showing us what this looks like. So law schools should be running law clinics and outreach programs that respond to the priorities of First Nations communities. They should be doing things to protect the rights of people in prison. They should be running strategic cases and providing advice. They should be doing things like clinics that provide advice on legal rights to First Nations kids, so they know what to do when the police confront them. And similarly, the judiciary should be visiting the prisons where they're sending so many people to understand what it looks like. I've interviewed many judges and many of them have said they've never seen inside a prison. So I think they need to do a lot of work building relationships and being accountable. And this should be part of a rite of passage for a judge and for a law professional.
Great, thanks, Thalia. George, I wondered if you could tell us about CopWatch, which is a really important, this community-focused strategy, and the kind of changes that it can facilitate.
Yeah, look, CopWatch is an educational program designed to train Indigenous children about how to safely film their interactions with police. It's not just about how you video and record, but how you do it safely and to de-escalate situations. It's also about training the differences between filming for evidence versus filming for advocacy, because they can be used in multiple applications. And most importantly, when to upload. Young people tend to upload everything immediately, and there can be real value in going and seeking advice from an elder or a legal service before uploading. But CopWatch has been incredibly powerful. I think it's changing attitudes to policing, and in many ways has led to the interest in the Black Lives Matter movement, because video evidence has been so powerful, both in court and for advocacy. Black Lives Matter probably wouldn't have had the same impact today without video. You wouldn't be able to compare the death of George Floyd, the horrific death of George Floyd, with the horrific death of David Dungay without video evidence. And quite frankly, it's unlikely that the narrative would be told truthfully without that video evidence. And Copwatch has been successful in having a police officer charged in Perth with running down a Noongar man. We've had charges against young people dismissed as a result of film evidence that was captured on video. And in recent times, it's been used to highlight police misconduct, where a 16-year-old Aboriginal boy was taken down by New South Wales Police in Surrey Hills. And I know that Carly's been working very closely with the family in that matter. So I think programs like Copwatch and filming the police and authorities when they're abusing their power has been critical to change.
Thanks, George. Carly, the first recommendation of the Royal Commission into Aboriginal Deaths in Custody was about self-determination. And I was wondering what role the Aboriginal community-controlled sector should be playing in the justice space from your perspective, and how can our legal services be better supported? It was interesting, there were a couple of questions coming through in the last panel asking about how the ALSs can be better supported.
Thanks, Larissa. The ALS opened its doors in 1970 in Redfern as not just the first Aboriginal legal service in this country, but the first free legal assistance service. We're turning 50 this year, and I want to acknowledge those activists. You know, it was founded as a response to injustice, a recognition of the failure of mainstream services to meet the structural, the cultural and the service needs of Aboriginal people. And Aboriginal and Torres Strait Islander people wanted a different model, community control. And it's that community control that sets Aboriginal and Torres Strait Islander legal services like the ALS apart. Community voices, cultural connections, and a deep understanding of the way that the justice system impacts Aboriginal and Torres Strait Islander communities is embedded in the way that we work. And that community control model is obviously driven by the self-determination, the knowledge that Aboriginal and Torres Strait Islander people know what our communities need to thrive. And just following on and acknowledging the great work that Copwatch has done from George, I think we have to acknowledge that Aboriginal and Torres Strait Islander people, you know, that wouldn't have been so successful if Aboriginal people weren't considering their kind of cultural obligations and protocols to allow this footage to be used. And I think that's been a huge thing, and we really need to acknowledge communities for letting that happen, because of course, to show some of that footage, to mention people's names, you know, is really difficult. So I think it's a reflection really for me that ATSLs and communities aren't, you know, distinct. They're not mutually exclusive. I do want to acknowledge that the ALS, like many legal services, is forced really to make really difficult decisions about where our services go. And of course, you know, we're dealing with things at the moment where I'm going to get 12 months of funding right now to do something. And I know at the end of that 12 months that money is going to go. And I'm going to have to explain to community that service is going to need to go. And this is the stuff that happens constantly, that we are on these sort of shoestring budgets that are not sort of adding to the baseline to continue to deliver the services that community need. And we're absolutely constrained. It is just completely horrific that we have got 2 family law lawyers in the ALS for the whole of New South Wales and the ACT. 11 care and protection solicitors trying to service 26 courts across New South Wales. And I completely understand when people are kind of asking questions about, well, why not this court, and why not this court, and why not this community? Because I too ask those questions. But there's something that I think really needs to happen for us at ALS New South Wales ACT, and that is that we need support to develop a general civil law practice at the ALS. And of course, increasing sort of the resources and support that we can provide to community in care and protection and in family law and in a criminal law context are not mutually exclusive. And we don't have a civil law service at the moment due to trying to make those difficult decisions around where we put that funding. But one of the big arguments that I have very regularly at the moment is why a community-controlled legal service delivering general civil law services is distinct from anyone or any other service who delivers civil law services, and of the need for the ALS in a self-determination sense to be able to support our communities with the issues that they bring to us. You know, it's just yesterday that I was having a conversation with someone and saying, I'm sorry, we don't do that work. And of course, then it's, well, why? And why why are you helping people in this area? And why won't you help me kind of with this particular problem? And so I think it's really critical for people to be standing up and supporting ALS New South Wales ACT to develop a standalone civil law practice.
Thank you. Well, that's something we can all get behind. Thalia, I asked you earlier about alternatives to imprisonment, but another area that you've done a lot of work in is assisting women, particularly with the transition out. And I wondered if you could talk a bit about what you've observed there and what needs to be done so that we can do better in that space to ensure that people aren't caught up in the system continuously. Yeah,
I think a lot of this knowledge importantly comes from the Koori women who are affected by this system, because they know the solutions, they are the solution. And I think it's like what Carly was saying, it's providing those supports around them to enact them. And for many of the women, the supports they need do relate more to the civil system than to the criminal system. So last year with Wiradjuri woman and researcher Gemma Sentance and Darug researcher Michelle Toy, I yarned with over 160 Aboriginal women in 6 New South Wales prisons, which on reflection was very fortunate because we know now prisons have been closed down due to COVID, and the women and men inside are suffering terribly because of that, as well as the increasing risk we're seeing in Victoria to their lives from COVID. Fortunately, we had many opportunities to sit down with these women over 13 visits, and we talked to them about how they were feeling about sentencing, their views on the prison sentence and what alternatives there could be. And unsurprisingly, they said that sentencing made them feel really upset and depressed. Some of them said they felt suicidal because they were so excluded from the process. They said the sentence of imprisonment was excessively harsh, not only for themselves, but for their children who are the invisible victims of a sentence. And they talked about the harms to their families. But more than sentencing, what they really wanted to talk to us about in these yarning circles was life outside of prison, especially for their children. They wanted to talk about, restoring their relationships with their children when they were released from prison, and the need for any transition to include their families. So if they were to go to rehabilitation, to make it a facility for Aboriginal women where they could have their children with them. And there are no facilities like that just for Aboriginal women in New South Wales. They wanted safe and stable housing. They wanted their welfare and the ability to pay off debts and provide for their kids. And they wanted to reconnect and give back to their communities. And I think what was really apparent in our discussions with the Koori women was that fundamentally they're carers. Almost all of them were mothers and grandmothers, and all of them would have been aunties, sisters, cousins. And they wanted to go out into the community and look after their kids, help with their schooling, take on jobs in aged care, set up businesses to care for the pets of other people in prison who couldn't be cared for. They wanted to set up cooking programs on the Mish. They wanted to do all these things that involved giving back. And I think if we can harness these roles among First Nations women and mothers and grandmothers, rather than locking them up, our whole communities would be stronger because of it.
Thank you, Thali. I just always love when you ask those questions to mob on the ground. They have the most practical, simple answers to intractable issues. George, I wanted to turn to you next. I think one of the interesting areas where you work in is really that intersection between, I guess, deaths in custody issues, but also the discrimination with the provision of health was obviously an issue that was looked at during the Royal Commission into Aboriginal Deaths in Custody. And I think in some ways your work in this intersecting space shows how far we've got to come. So I was wondering if you could talk a bit about that work and the kind of cases you see where the failures in both systems interconnect with devastating impact on First Nations people.
Yes, and as you point out, a lot of the focus of the Black Lives Matter movement has been on policing and incarceration. But as you just pointed out, the Royal Commission into Aboriginal Deaths in Custody did make the observation about the intersection between healthcare and Indigenous deaths. And, you know, the average person presumes that prejudice doesn't exist in a helping service like healthcare. But the problem is that prejudice is insidious. And you may recall that the late Dr. Yunupingu was left for 7 hours on a stretcher in Royal Darwin Hospital because clinicians thought that he was drunk. He hadn't been drinking at all. Everyone knows that he had a serious kidney disease, and that was the cause of his state. But stereotypes are assumed by non-Indigenous doctors and nurses and midwives, and that led to Dr. Yunupingu not receiving appropriate care. The same happened with Miss Du. She was stereotyped as a drug user, and her legitimate and very serious claims for healthcare were ignored, and she was accused of being a faker until she passed away in custody. Naomi Williams, a 26-year-old Aboriginal and Torres Strait Islander woman from the Tumut region, was presented 15 times, many of which was during a pregnancy, to Tumut Hospital. Each time she claimed she was being stereotyped as a drug user. Her serious illness was ignored, and she ultimately died after she was turned away from the hospital on the last occasion with septicemia. We see cases of stroke victims who are assumed to be alcoholics. And these prejudices play out in shocking ways. David Dungay was actually being held in a prison hospital. New South Wales is the only state in Australia that has this strange confection of prison and healthcare, and it was that intersection that led to David's death. One of the good things about the New South Wales Deputy State Coroner was she saw racial bias as contributing to Naomi's death. She made a number of very powerful recommendations about employment targets and auditing for bias and racism and identifying tools that could be used to overcome the systemic bias in the system. And the Williams family has pushed the Health Minister in New South Wales to accept all of those recommendations, and hopefully we'll start to see the health system addressing that issue.
Thank you. Mindful of the time, and I do want to get in a couple of the audience questions. My final question is to each of you, so I might just do a quick whip around just to hear from you what you think our key areas of reform should be in your, just from your own personal perspective. What are a couple of priorities that you'd like to see come to the forefront? And I might start with you, George.
Look, I'll just pick up Chris Cunneen's comments earlier on decolonising the institutes of the state. I agree with Carly about measuring what we want to change, holding governments accountable for not achieving those targets, and fund and support community orgs like the ALS and the Peaks. I won't go on. I'm sure others have many more suggestions.
Yes, I know we've all got a whole raft of them, so I was a bit cheeky in asking you to just pick a few. What about you, Thalia?
Okay, I might give you a bit of a laundry list as well quickly. Look, low-hanging fruit, I really believe that we need to stem the tide of bail reform, which has contributed to rising remand rates. Over 30% of Aboriginal people in prisons are there on remand, not proven guilty, not sentenced. And then over 50% of Aboriginal kids on remands. I think it's a quick fix. I think with COVID, we've seen that where there's a will to reduce remand, there's a way, and certainly the courts have been much more open to granting bail. There also needs to be reform in sentencing. We need to do away with this risk and punitive mentality towards Aboriginal people and introduce more information that gives justice and light to Aboriginal people's holistic lives and experiences. We're seeing this with the ALS in New South Wales and its bugbear reports. We're seeing this with the Victorian ALS and its Aboriginal community justice reports. So they're trying to provide a narrative-based report to humanise Aboriginal people in the courts, to place a check on racism in the courts, and to promote non-custodial sentences. And just to finish off, I really do believe that we need to shift the focus from prisons to self-determination, to looking at Aboriginal-led safety, health, justice programs, initiatives such as Aboriginal women's shelters and centres, support for children, night patrols, restorative justice, and essentially making sure that the prison and police system are kept accountable, not only for deaths in custody, but for every single interaction with a First Nations person.
Thanks, Thalia. And Carly, I know you would have a very long laundry list, but what would be at the top of it? What are some of your top priorities?
Try and be as quick as I can, Larissa. Look, time-wise, I am so deeply concerned right now that COVID has entered prisons in Victoria, and New South Wales and the ACT need to act immediately to get people out before it is too late. We also are seeing the Council of Attorneys General meeting on Monday in relation to raising the age, and this has to be a huge priority so that we stop locking up 10-year-olds in barbed wire facilities, strip searching them and giving them limited access to peers, teachers, supports. And I also just wanted to perhaps end with saying I know we've sort of focused largely on a criminal law context today, but in terms of child protection, we need to introduce legislative amendments to incorporate active efforts to require the authorities to undertake early intervention casework with the family prior to removing a child. And I just want to make sure that we have mandatory use of early intervention legal tools that promote Aboriginal and Torres Strait Islander children remaining with their families and within their communities.
Thank you so much. Well, that's a great place to start, though. Obviously, just a the tip of the iceberg of a larger reform agenda. If I can just go to a couple of questions now, and I have to ask this one. Tracy is a 60-year-old First Nations lawyer, and when she finishes her law degree at the University of Newcastle, she's asking what would I be best suited to make the most impact for change? What area would I be best suited for to make the most impact for change? So good on you, Tracy. That's already inspiring, just getting out there and showing everyone what you can do. So I don't know, maybe I'll start with you, Carly, and then go to you, Thalia, for advice to Tracy.
Thank you. Tracy, I'm not sure I'm the best person to give you advice, considering at law school, the one area I didn't want to practice in was criminal law, and I became a criminal defence lawyer. And so my advice to you would be to try anything and everything, and don't rule it out for whatever reason, even if that's people tell you you must come out of university and you must, go on this particular path. It's all crap, really. You find your own path and you find what it is that you like, and I'm sure that you will be great at it.
Thalia?
What I would say, Tracy, without trying to deter you, is that it's really hard work working within the legal system, and probably the other panelists and Larissa are much more qualified to say this, but I only spent a very short time. I remember going down in Bajura in Glebe, which was a children's court, and seeing a child behind a glass sheet, and that, I think that was pretty much it for me. So I think just find something that you're passionate about, and try and do it, I guess, in a way that, is true to your values, but is going to give you longevity. Pace yourself. Don't feel like you have to do anything. Start, it might be a local ALS, or it might be a community law centre. It might even be a private practice, but start somewhere where you feel you can contribute in a small way. And at the end of the day, we are lawyers in our work, but our whole lives are a broader contribution, and don't feel like you have to do everything in your job.
I'm sure wherever Tracy goes, she'll make an impact. I'm just going to try and squeeze one more question in, and I'll direct it to you, George. And it's from Shelley Murphy-Oates, and I'm not sure it has an answer, but it is a really good question. We've heard a lot about practical solutions, evidence-based outcomes, evidence-based research. Why isn't there more political sway around this? Why aren't governments implementing these solutions? Any thoughts, George?
I think that's a really good question.
Good question.
And I think that the government intentionally does not measure bias and racism in the system. So we're not measuring the right things. If you look at the closing the gap measures, they often blame, and I use quotes, the victim. They measure things like school attendance and smoking rates, but they don't measure the impact of racism and prejudice and colonialism on adverse outcomes. So I think that there is a political argument about what we're measuring, what evidence-based facts we're looking at, and policies we're looking at. And I think the critical issue is to have Indigenous organisations and peaks and people involved in the programs and looking at what we're measuring, because what you're seeing now is a colonial system measuring itself and turning the focus away from its miserable conduct. And I think until we start involving Indigenous orgs and Indigenous people in the decision-making process, the policy-making process, and the measures, you're not going to see change.
That was a great short answer to a complex question,
Sorry.
George. No, it was excellent. I threw that at you at the last minute. So I want you all to imagine thunderous applause as we thank Carly Warner, the CEO of the Aboriginal Legal Service New South Wales ACT, Thalia Anthony, Professor at the Law Faculty at UTS Sydney, and George Newhouse, who heads the National Justice Project and CopWatch. Thank you to Redfern Legal Centre and the National Justice Project and the Jumbunna Institute for supporting today's event. And thank you everyone for taking the time to listen to these great voices and these great issues. And I hope it motivates you to keep on going to make sure there's change. Thank you.